Welcome to Knowledge Sharing webinar organized by Mehta and Mehta. Today's topic on Masterclass series on issue of security is an insight into the issue of preferences, optionally convertible preferences, and compulsorily convertible preferences. We have intentionally added these two both with the preferences, though they are preferences, because you will understand during the webinar that how they are complicated and how it can be used by the corporate. Today's presenter is Ms. Sakshi Gupta, Associate Partner of Mehta and Mehta. And she is CS and Commerce graduate and Law graduate, and previously worked with MCX and has experience in the field of incorporation of LLP company, conducting board meeting, compliances, LODR, security law regulations, SEBI prevention of insider trading, and NBFC compliances. Today's our panelist is CS Amit Gupta, who is, I think everyone knows, and we are fortunate to have him on our panel quite a few times. Amit Gupta is a fellow member of ICSI, insolvency professional, and he is in practice in the profession since last 23 years. And he has contributed extensively to the profession through various roles in ICICI, including member of NIRC, ex-officio member of Managing Committee of Lucknow chapter, and chairman of Research Publication Committee. He has also served on the Secretarial Standard Board, Auditing Standard Board, and several core groups and task forces. He has been member of Company Law and Corporate Governance Committee of PhD Chamber and National Council of ASSOCHAM on Merger and Acquisition. His publication includes ICSI Premier on Company Law, Voluntary Liquidation, and the Handbook on Interim Resolution Professional. His key contributions include Vision New ICSI 2022, Compliance Management, and Audit Configurator, and the new syllabus for the Executive and Professional Program. He is also visiting faculty and regular speaker at various institutes and conferences. Welcome, Amit. Thanks a lot for your time. As usual, Mr. Bala is there. Friends, today Sudhakar is not there. He is busy with some other assignments. And so with this, we will start our presentation as usual. I'll request Amit Gupta to say a few words on the topic, and then Mr. Bala, and immediately in 5 minutes we'll start the session. And during the session, the panelists will share the views and the experience on the topic. Friends, preferences, we have done this topic twice or thrice, but each time the queries are very different. And of late, if you observe, after 2013 Act, preference shares are utilized very trickily by the corporates. It's a kind of capital structuring tool for any corporate. The coin word is because it is included as a share capital in the Companies Act very clearly, which contribute to the net worth of the company. And here is the clue how you use the preference shares, which is compulsorily redeemable. That is repayable to the investor. And still, it gets a color of equity. So wonderful instrument if it is utilized in structuring very well. With this, I'll request Mr. Amit to say a few words on the topic, and then Mr. Bala, and then Sakshi can start the presentation. Over to Amit, please.
Yeah, thank you, Dipti ma'am. And thank you, Mehta and Mehta, for organizing this webinar series on issue of security, and especially giving me an opportunity to share my thoughts on the instrument of preference share. So, as rightly highlighted by Dipti Madam regarding the unique features regarding the preference shares, it is a hybrid instrument which has the colors of equity as well as debt, and it has certain specific voting rights, and it has a potential to gain voting right on all matters depending on trigger of certain situations with regard to non-payment of dividend. The option to redeem is also one of the feature which attracts this particular instrument, especially when we are now in the age of startups. There are quite a few startup companies who are using this particular instrument, whether it is optionally convertible preference share, whether it is compulsorily convertible preference share, or whether it is a redeemable preference share. So there are different nuances. Although if we talk about scope and coverage, there is only one section, that is 55, which is dealing with the subject of preference share, but still the importance is very high if we talk about the coverage and the role that the preference share as an instrument plays. I think with these words, we can begin the discussion on the nuances of the preference share. Let Sakshi begin the presentation, and as and when we are required to make deliberation on the different facets of the preference share, I think we can go ahead. But certainly one thing is very sure, that in today's time, when we are seeing a new age entrepreneur coming up who want to structure their capital, and at the same time they want the net worth to be enhanced to meet their various capital requirement norms, I think this instrument has played a very vital role and will continue to play a very vital role. I think I'll stop over here, and I'll request
Mr. Bala.
Sakshi. Yeah.
Mr. Bala, few words. And Sachi, you start sharing the screen, please.
Good morning to all of you. I have a great pleasure in welcoming you all for this session. As Amit puts it, it's only a one particular section. It's a very small topic, but the intricacies are too high. Because when you talk about the treatment, he said actually, it's you have the colors of the equity as well as the debt. It is true. When you come to the today's accounting, it is actually told long-term borrowing. The dividend are actually treated as cost to the company. It is profit and loss account. It is charged, although it is declared from the divisible profit. So question arises when you talk about the long-term borrowing and it is the debit to the P&L account, whether it requires to be declared by the board of directors, recommended, and shareholder declare the dividend or not. That is one number question. Because treatment in the accounting is something different. But at the same time, although we say it is a capital, but it is redeemable 20 years, again out of the profits. There are too many constraints are there actually. And another thing is there, if the company is not able to redeem, what happens? Then the big question arises, what are the ways out? I must also tell you, even before we started the discussions, I can see almost closer to 150. Yesterday itself, somebody has actually the questions we already received in advance, which we'll be discussing during the course of the question. The question is whether the preference share can be issued by way of the bonus share to the equity shareholders. This is the question yesterday, which has actually come up. Anyway, it is a very important topic, and we have a expert, Amit Shah, who is a hands-on experience on this. Will be sharing his practical experiences. As he rightly said, we'll keep deliberating the thing. Please put down your questions on the chat box. We will take it periodically. We will take forward. Over to Sakshi, please. You can begin the presentations.
Good morning, everybody. So our today's topic for the masterclass on issue of securities is insight into the issue of preference shares, CCPS and OCPS. Before getting into the detail of issue of preference shares, we need to understand what are the preference shares first. So preference shares has been defined under Section 43 of the Companies Act 2013, and basically these are the shares which have the preferential right over the equity shares relating to the payment of dividend and repayment of capital in case of liquidation. Preference shares may also have additional rights which would be preferential over the equity share. However, they would not ever change their rights or relating to payment of dividend and capital in case of liquidation ever. With respect to the same, we need to understand over here that the preference shares holders are also the shareholders of the company. Accordingly, they will always be considered as the members of the company. So any right which has been given under the Act to the members would be the same right given to the preference shareholders as well. For example, they have all the right relating to receiving notice with respect to the general meetings, receiving annual reports. Even they have a right to attend the general meetings as well. In no situation, preferential holders cannot be given these rights. In fact, the companies are also required to maintain the register of members for the preferential holders as well. So they are the shareholders of the company, though the category of the capital is different, but all the rights given to the members of the company are required to be given to the preferential holders mandatorily by the company. They can participate in the dividends along with the equity shareholders beyond their preferential dividend. Preferential holders can participate in the surplus capital of the company during winding up after repaying their capital. However, preferential holders do not hold the voting rights in the company. In certain situations, they get the voting rights, but in generally, the major difference between the equity shareholders and the preference shareholders are that they do not hold the basic voting rights in the company. Now, there are different types of preference shares which we can discuss about. However, in today's topic, we will be discussing in detail regarding the convertible preference shares, which will be including CCPS and OCPS. But the preference shares, as it is very obvious by their names, there are 5 kinds of preference shares: convertible preference shares, non-convertible preference shares, cumulative and non-cumulative preference shares, redeemable and irredeemable preference shares, participating and non-participating preference shares.
Amit, this irredeemable, actually, I always surprise. Irredeemable we say, but we say that it is always redeemable. But whether we can tell irredeemable, only change the color and then it will be irredeemable. But you can say that convertible. If that take the color preferences, take the color of equity, then it become original preference shares irredeemable because it changed the color. Otherwise, irredeemable preferences possible. We are telling that.
The intention of the lawmaker by classifying, because if I go in the history, 1956 Act, Companies Amendment Act 1988, first time brought the concept of tenure, by which it mentioned the maximum permissible tenure for redemption is 20 years. Right from there, the concept of tenure started. Prior to that, perhaps there could have been a situation of a perpetual preference shares. Right now, the concept of perpetual preference shares has been a kind of done away with, except with the limited rider that you can reissue the preference share and redeem the earlier preference share, and by that you can continue the perpetuality. The idea is that you can't have a perpetuality regarding the tenure of the preference share, which are redeemable in nature. So they have put the cap that if you are
Yes.
Other than infrastructure company, then it will be 20 years. If you are infrastructure company, then it will be additional 10-year available, but with certain condition that at least 10% of the redemption will start from the 21st year onward. Now, that is the crux, what I understand.
So I think as on today, it is not, you can say valid, but maybe earlier.
Yeah.
Yeah, today there is nothing called the
Irredeemable.
redeemable preference share. It's all non-redeemable only because it is only 20 years tenure. That's it. Either 20 years or 30 years, as Amit puts it.
Okay. Yeah, Sakshi, go ahead.
Convertible preference shares are those preference shares which provides a right to the equity shareholder, right to the preference shareholders to either convert their equity shares compulsorily or optionally. So basically, the preference shareholders has the right to either convert it into the equity or get it redeemed. So basically, there are two types of convertible preference shares, which is compulsorily convertible preference shares and optionally convertible preference shares. So compulsorily convertible preference shares, as by its name it suggests, it means the preference shares which has been issued and are converted into equity shares after a predetermined period. Whenever the preference shares are issued, all the terms related to the issue and its redemption or its conversion are predetermined in the while issuing the preference shares. So in CCPS, there is it is a requirement that at the time of the conversion, the investors cannot opt out of the conversion. That means it is mandatory for the investors to convert their preference shares into the equity shares. However, there is one exemption to the same, which has been it's like a right to those shareholders under Section 48 of the Companies Act. However, we will discuss about detail at a later stage in the same presentation. Some key features of CCPS would include that it would be automatically converted into equity shares as it would be predetermined at the time of issue. There would be a fixed conversion ratio, the amount of shares of preference shares that would be converted into equity shares. For the regulatory classification, CCPS would be considered as equity under the Companies Act and FEMA. Valuation has to be done on fair market pricing guidelines. And since the CCPS would be converted into equity, there would be no redemption for those shares. Now, optionally convertible preference shares, OCPS. So these OCPS are those preference shares which gives an option to the shareholders to either convert into equity shares or get it redeemed. It gives a leverage to the shareholders to decide what they want to do with those preference shares depending on the market performance, stock performance, or other factors as it is important to them. Some key features of OCPS would include that there is always an option for with the investors to either convert or continue holding as a preference share. It gives more flexibility than CCPS as there is no mandate on the shareholders. Conversion pricing or either the redemption pricing, all these terms would be predetermined. Voting rights are not given to the preference shareholders. I mean, there are limited voting rights which has been given to the preference shareholders, which would remain same for both OCPS and CCPS.
1 minute. Sakshi, go to previous slide.
Yes, ma'am.
I think Amit, just pricing mechanism, can you will like to say
I will explain. See, when we are discussing the concept of compulsory convertible preference share or convertible securities, essentially, whether it is OCPS or whether it is compulsory convertible, other than the redeemable preference share, the preference shares which have a characteristics to get converted into equity are one bucket, and the preference shares which are redeemable either at the option of the company or at the option of a preference shareholder will be in the different bucket. If it is a pure and pure redeemable preference share, the pricing guidelines are not applicable either under FEMA nor under the provisions of the Companies Act. Now, if your preference share is convertible, in addition to the provisions of Section 55 and Rule 9, you will also be subjected to compliances under provisions of 62(1)(c), that is the preferential allotment, read with Section 42, that is the private placement, as the case may be. Because it is potentially convertible into equity, the equity shareholder rights are impacted. So accordingly, 62(1)(c) and essentially the 62 section has to be in compliance. Accordingly, Rule 13 will also come into play, and Rule 13(2)(h) of the company's share capital and debenture rules prescribes you with two options. If you are issuing convertible preference share, you can make valuation of preference share upfront at the time of issue of these preference share, or you can choose the option to do a valuation later at the time of conversion. The conversion may happen, let us say, 3 years down the line. So at the time when you are deciding to go for conversion, at that point of time, you may decide to go for valuation. It is as per the provisions of Rule 13(2)(h). As such preference shares, there is no intrinsic value, although they can be valued basis what is the rate of coupon, what is the value, but in the terms of the Companies Act, I don't see there is any reason to assign any specific intrinsic value to the preference share. The value of preference shares which are convertible is always dependent on equity. So you do the valuation of equity, and basis that you decide what is the premium that has to be charged on conversion of preference share into equity. That is the basic premise. As far as if you are issuing a redeemable preference share, in those cases, the concept of pricing will not be applicable. You can issue it at par value, or you can issue at premium as you wish, as the company wish. There is no restriction as such, and they will not be governed by the provisions of Section 62. They will be governed by Section 55, read with Section 42, unless you decide to offer these preference shares on the rights basis. I think that issue can be parked for a later discussion. There was some poser also. Somebody has raised a question whether we can issue bonus or rights, that we will discuss little later. But on the pricing mechanism, I think two things which are fundamental. One, if it is redeemable, no pricing guideline applicable. If it is convertible, pricing guideline as per Rule 13(2)(h), read with 62(1)(c) will become applicable. And we have to do the valuation either upfront or do the valuation at the time of conversion. And underlying security which will be valued will be equity. I think that gives a...
Yeah, thanks. Yeah, and so corporate will decide based if the corporate think that in future the profit will be high and they will get good valuation, then they delay the valuation. And if they feel this is the right time, they will value that. And the number of equity shares which will be converted accordingly, it will be valued. Yeah, we can go ahead, Sakshi. Yeah.
Excellent explanation, Amit, because you touched upon very clearly. When it is redeemable, it still continued to be a debt. There is no question of valuation arises at all. Once it is get converted, it is always linked to the equity share, the valuation becomes necessary. You very clearly touched upon the points. Very nice. Thank you. Yeah, go ahead, Sakshi.
So for the dividend, as we've already discussed, preference shareholders have always preferential right on the dividend over equity shareholders. So OCPS have the same right. And for the redemption, if not converted OCPS, then it would be redeemed within maximum 20 years timeline. If it is converted into the equity share, then there will be no redemption. So we have discuss CCPS and OCPS individually. Now we'll see the major differences among these. For the conversion, CCPS are mandatorily required to be converted. However, in OCPS, there is always an option with the investors. Either they want to get it converted or redeemed at a later stage. Investor control. In CCPS, investors has no choice. However, in OCPS, investors has the choice or they have an leverage to decide on what they want to do. With regard to the voting rights, they are same for both CCPS or OCPS. Both the preference shareholders possess limited voting rights. However, if the CCPS or OCPS converted into equity, then they will have equal voting rights as the equity shareholders. Then FEMA treatment. CCPS will be considered as equity instruments. However, OCPS will be considered either equity or debt depending on if it is getting converted or not. For the risk profile, CCPS, I would say, is a very more, it's less riskier because the investors have the security that they will eventually be the owner, equity shareholders of the company, and they will be the owner of the company. However, in OCPS, there is always a higher risk. They might not get converted into equity shareholders and would eventually be the debt of the company. In regard to redemption, CCPS has no redemption. However, OCPS is also a choice. If not converted, then it would be redeemed as per the Companies Act 2013. So there are certain conditions with regard to the issue of preference shares which a company needs to fulfill. Yes, sir.
I think let us spend some time to understand from the company perspective as well as the investor perspective, suitability of CCPS versus OCPS. Because when we are dealing from the company standpoint, what is the trigger and at what point of time and what factors should be considered for the issuance of CCPS, which instrument should be chosen, right? From the company standpoint and one from the investor. So let us see from the company standpoint. If a company consider when CCPS would be idle, CCPS would be idle in the situation when company considers that they will never have or there is a likely possibility that they will not be in a position to redeem because of the cash flows in the future. Their cash flows are little uncertain or the premium that the investors are expecting over redemption are likely to be on the higher side. Now, suppose they have issued at par value and they are expecting equal amount of premium at the time of redemption. If it is so, then company may not want to shell out spending of the outflow of the cash of that much quantum. Now, so they may decide to give an option to convert those securities into equity so that there may be some dilution, but there will be cash available with the company for running the operations. On the other hand, suppose company is having lot of surplus cash to be generated, but as of now, when they are starting with the project, they are short of capital, they are short of cash. So they infuse the capital by issuing a redeemable preference share or optionally convertible preference share, and they generate cash over a period of time and they redeem the debenture, they redeem the preference shares and they bring their original equity to the normal level without diluting it to the preference shareholder, right? So that is the one basis on which you can say the company can decide whether to go for CCPS or OCPS depending on availability of cash surplus in the future. Similarly, for if you think between the optionally convertible preference share and CCPS, I am keeping the option available with me that whether I will go for redemption or I will go for preference share. Now that option can also be with the company, or I can leave this option to the investor. So suppose I am keeping option with me, that is company. I will keep the option with me when I am uncertain whether I'll be having surplus cash available or not. If I get tomorrow surplus cash available, so let us say I have issued the preference shares for the tenure of 10 years. So I say company will have an option to redeem on or before 10th year, or maybe you can say 9th year, right? And if company fails to redeem any time prior to expiry of 10 years, they will be compulsorily convert, or the investor will have an option to convert them into equity. So these are the conditions primarily or generally in which the instrument selection is dependent on, and there could be many other factors. I'm just indicating that these are couple of factors. Similarly, when investor is negotiating, he will consider the reverse situation. Investor would always like the equity participation if the value of equity is likely to increase over a period of time, instead of the premium that they are going to get over a redemption of the preference share. If the value is going to be more and they consider in long term equity will be much better instrument, so they will go for having an option in their hand to convert the security. On the other hand, if they feel that company is little consistent, or the profits are not, they are not very sure about the valuation in future, they may like to have a option to redeem at the early stage also. So they will like they have a premium of 10%, 20%, 30%, and they better have an option to exit out from the security. Now, that is the primarily distinguishing feature with regard to CCPS and OCPS. Yeah, Sakshi, you can proceed.
Yeah, right.
Amit, when you're talking about the preference share, I think like equity share, the preference share also can be issued at the premium, can be
Yes.
redeemed at par at premium, it can be
Yes.
redeemed at the discount. All those options are also available, correct?
Yeah.
We will come to the redemption option separately. I think once Sakshi make a discussion, because there are a couple of points. But as far as issue of preference share at a premium is concerned, there is absolute clarity. We can issue the preference share at a premium or at par, as the case may be. There is no restriction as far as the legal provisions are concerned.
Okay.
So, very well said. As we discussed in starting of the webinar only, it's a very good instrument. I use the word instrument because based on the requirement of the company of liquidity or of sharing the ownership right, or based on the growth and valuation, the company can issue and structure this security based on the timing. It's a very good instrument available in the Companies Act. Okay, Shakshi, go ahead.
So there are certain conditions which needs to be fulfilled by the company before issue of preference shares. So the very first situation would be it should be authorized by its articles of association. If not, before issuance of preference shares, company needs to alter its articles. The issue of preference shares is authorized by the shareholders of the company by passing a special resolution in its general meeting, which gives a clarity over here that the board of directors themselves cannot issue preference shares. It needs to be approved by the shareholders of a company through a special resolution. The company's share capital needs to be bifurcated into equity and preference share capital. Here, I would like to take a moment and to explain this, because this has been seen that companies sometimes get confused over here. In case of issuance of preference shares, companies needs to have authorized preference share capital as well. The authorized equity, through the authorized equity share capital, they cannot issue preference share capital. Let's just say if a company has a 10 CR authorized capital and they want to issue equity and preference. So out of that 10 CR, both preference and equity share capital needs to be authorized share capital.
Yeah, very well mentioned by Sakshi. One more point for caution, I have seen many companies memorandum of association with regard to authorized share capital clause. The authorized share capital of many companies is worded. The authorized share capital of the company shall be, say, rupees 100 crore divided into 1 crore equity share of rupees 10 each, aggregating to rupees 10 crore, and 9 crore 10% redeemable preference shares of rupees 10 each. So aggregating to 90 crore. So 10 crore equity and 90 crore preference. But here the catch is that you have defined the terms of preference share, wherein you have stated the coupon rate is 10% and they are redeemable preference share. Now you are in a cash 20 situation. If you tomorrow want to issue the preference share at a 9% coupon rate, perhaps you don't have a capital. Law does not require you to specify the coupon rate, whether they are, what are the terms associated to the preference share, whether they are convertible, whether they are redeemable, whether they are OCPS, whether they are CCPS. Ideally, we should not include all these specific characteristics or the specific terms in your authorized share capital. You should leave these for the decision by the shareholders at their meeting, so that you have a flexibility in issuance of these securities later on, and you need not increase the specific authorized share capital later on. I think that is just a small addition to what Sakshi was mentioning.
So while issuing the preference shares, there should not be subsisting defaults in relation to the payment of dividends due on existing preference shares of the company. There should not be a default in relation to the redemption of existing preference shares at the time of issuance of new or proposed preference shares.
Sakshi, I think your voice is reduced a little loud. Yeah. You can speak little loud. Yeah.
So there are 2 points. There is one point Sakshi just noted down. We will discuss it little later regarding the subsisting default. Right. This is very interesting point, and when we will be discussing the changes from the 1956 to the new law. Right. I think at that point of time we will pick this point again and continue the discussion on this thread, because what is the meaning of subsisting default is very interesting in the case of a preference share, whether with regard to dividend or with regard to redemption.
Sure,
Yeah.
sir. So as we have discussed that preference shareholders are the members of the company. So accordingly, register of members under Section 88 of the Companies Act must include the details of preference shareholders as well. So the preference shares now can be issued only for maximum time limit up to 20 years. However, there is an exemption to the same that the companies engaged in the business of infrastructural projects can issue preference shares for 30 years. However, they need to, from the 21st year onwards, at least 10% of those preference shares needs to be redeemed annually on a proportionate basis. So the whole process of preference shares under Companies Act would include that first the board meeting is required to be held by the company for issuing the preference shares, and the notice for the same, for like the 7 days notice to the director needs to be given. Then a general meeting will be held wherein a special resolution for the issue of preference shares shall be passed by the shareholder. After that, Form MGT 14 needs to be filed regarding the notice and the resolution of the general meeting. Here we need to pay attention that through MCA circular, private limited companies are exempted from filing Form MGT 14. However, there is no exemption from filing special resolution in Form MGT 14. So all the companies are required to file Form MGT 14. Then PAS 3 shall be filed for the allotment of the share, and then the share should be issued. So till March 31st, shares were issued through the certificates. However, through the amendment under rules of companies prospectus and allotment of securities through rule 9B, every private company other than small company are required to issue securities only in dematerialized form. And it says very specifically issue of securities, which will always include issue of preference shares as well. So now company needs to issue preference shares only in dematerialized form only. Unless they are small companies, they can issue in the physical forms as well.
Yeah. Sakshi, just one very interesting scenario or a situation that we have very recently came across is with regard to this dematerialization of preference share and generation of ISIN. A word of caution for all the professional, which generally we miss out while doing a negotiation or finalization of terms and condition with the investors, right? The point that needs to be kept in mind while doing a negotiation with the investors is regarding the tenure of preference share, right? Or the terms and condition of these preference share. What happens generally is we are doing a multiple round of issuance of security. And many a times the terms and condition with different set of investors are different actually. And because the terms are different, so different ISIN will be allotted. But in one of the situation, what we have noted that they have issued rest of the terms are same. The coupon rate remain 6% in all the tranches in which they have issued the securities. They have issued the securities in almost 85, 90 tranches over a period of time, right? Over the period of just 2 years, right? And each time they have issued the preference share with tenure of 10 years. Now, what happened if I issue the security today with a tenure of 10 years? The ISIN is different. Now, if 10 days after I am issuing another security, though all the terms remains the same, but because the tenure is again 10 years from today, when you go to depository will create another ISIN for the same. One way, and they have created almost 80, 85 or 90 ISIN over a period of time unnecessarily, which was not required. What could have been done, because the tenure is very same almost. The intention was not that that we should have a different security. What we could had done, we could had stated that these preference share will have a maturity date as of 31st of March 2030 or 2034, whatever, right? So once you fix the tenure, your all ISIN will become common. You need not issue. Maybe you issue in one tranche or you issue in 100 tranche. Your same ISIN will work for all the further round of security. So that's way we can reduce the number of ISIN, we can reduce the cost, and we can reduce the complexity in the issuance of security also. That is just a practical point what we have noticed very recently. So I thought I'll just share with in all the participants to take care of these small points when they are structuring the instrument for the purpose of issuance. Yeah.
Very good issue, Amit. Very good point you have brought out, really speaking. Otherwise, unnecessarily, it increased so much administrative cost and again, servicing, keeping a track and other thing and all. Very good. I appreciate. Yeah.
So for the special resolution, there needs to be certain information which should be a part of the resolution before putting it to for the shareholders for their approval. All the information with respect to the right of the shareholders in relation to the repayment or the payment of the capital or the payment of the dividend, share of the preference shareholders in the surplus funds, the conversion of the preference shares if in the equity, the payments of the dividend, whether on a non-cumulative or a cumulative basis, the rights of preference shareholders in the surplus profits or the assets of the company. If it is getting redeemed, not converted, then the redemption of preference shares and the voting rights of the preference shareholders when it would be triggered. So these are the certain information which shall be part of the special resolution. However, very detailed information with respect to the issue of preference shares shall be part of the explanatory statement, which has been circulated along with the notice of the general meeting. It should include the details of the type of the preference.
Amit, somebody is actually asking, can you please avoid, can we avoid repeated ISN for the future allotment? Can you please repeat what you said?
Yeah, I think we can unmute Chandrasekhar if it is possible. I think I would like to understand little better from him what is his exact query.
Then we can take it later, Mr. Bala, because queries are too many.
Okay.
We park it here and we'll take it later because
Okay.
many are there. Yeah.
Okay.
Yeah, Sakshi.
So the explanatory statement is required to be circulated along with the notice of the general meeting and shall include the details relating to the types of preference shares which is required to be issued, issue size, which will include the number of the shares, their nominal or the fair value, the manner of issue of preference shares, the reason why the preference shares has been issued, the issue price, condition if there is any specific condition with relating to the issue of preference shares, calculation of the price of the preference shares, timeline of the redemption or it would be redeemed at the premium or par, whether the preference shares would be converted or not, the current shareholding of the company, and in case of the convertible preference shares, if it is converted, then the proposed shareholding of the company at the time of the conversion, which will include the dilution of the equity shareholders of the company as well. So now we will be discussing the variation of shareholders' right, which is yes, sir.
Yeah, Sakshi, I think very important point that we should all note. The explanatory statement explained by Sakshi is pursuant to the provisions of section 55 read with rule 9 when I am issuing preference share. These are specific disclosures which are triggered from rule 9 if I am issuing a preference share. But please understand, if you are issuing convertible preference shares, the provisions of section 62(1)(c) will also be applicable. Accordingly, rule 13 of company share capital and debenture rules and rule 14 of prospectus and allotment of securities rules will also become applicable. That is section 4262 also prescribe for certain disclosure in the explanatory statement, and that has also to be taken care adequately when you are making disclosure in the explanatory statement. Don't just miss out, because many a time we have seen that the professionals who are making disclosure in the explanatory statement in the EGM notice, they are only including section 55 disclosure. They are forgetting the disclosures which are triggered by virtue of provision of section 4262. So that cannot be ignored, because you are issuing the securities either on a private placement basis or on a preferential allotment basis, as the case may be. The applicable disclosures will also be included in the explanatory statement. That is the point that I wanted to emphasize. Yeah, Sakshi, go ahead.
Now, the variation of shareholders' right, which has been explained under Section 48 of the Companies Act 2013, which we discussed at the time of discussing the CCPS, compulsorily convertible preference shares. So basically, this particular section is a section which is giving rights to the shareholders to change or to give the variation in their existing rights. So, any rights associated with the class of shares can be varied with the written consent of at least 3/4 shareholders of the value of that particular class. It can be varied through a special resolution passed at the general meeting of that particular class as well. The variation attached, if the variation of the rights is attached to the one class of shareholders but affects the other rights of the other class of the shareholders as well, then the consent of the 3/4 value of those shareholders whose rights are affected needs to be obtained as well. For the variation of shareholders' rights, MOA and AOA shall be having a provision for the same. In case it does not have any provision, it should not be prohibited by the issue terms of that particular class of the shares. And the shareholders who do not wish to give the variation to the shareholders, then at least 10% of the issued share of that particular class can put a petition to NCLT to cancel that particular variation. And it would be the variation would be cancelled only upon the approval of NCLT only. By mere giving a petition will not cancel the variation in the shareholder side. Now we will discuss about the CCPS here, that it has been explained that investors cannot out of the conversion from compulsorily convertible preference shares. However, if the CCPS holders feel that at the time of conversion they do not wish to go for the conversion into equity shares, they can use the right under this particular section, and they can hold a meeting of the preference shareholders, and if the 3/4 value of the shareholders gives their consent in writing for the variation in their right to not convert those CCPS into equity, then the CCPS cannot be converted in equity as well. However, in case if certain shareholders wish that their shares to be converted into the equity shares, then that shall be done forthwith. Their share should be converted into equity. Amit sir, you want to discuss this in detail or shall I go further?
Yeah, I think there are a lot of questions. So we will park all the questions regarding the variation there at itself. I think by and large, the provision what you have explained is pretty simple, that if I am intending to make variation with regard to the rights of a class of shareholder, so I have to obtain the consent of 3/4 majority of that particular class. And if the other classes of shareholders' rights are also impacted, they will also require the consent thereof. And if the other class is equity, so equity shareholder consent will also be required. So there could be multiple scenarios where you are changing the rate of dividend. There could be scenario where you are changing the tenure of preference share, convertibility, redemption. So if they are impacting the equity shareholder rights, or they are impacting the other shareholders, that is other preference shareholders rights, so the concerned other class of shareholder consent will also be required. I think that needs to be planned adequately for the purpose of getting this variation approved. Yeah, Sakshi, I think. Yeah.
Now we will discuss the redemption of preference shares. So the preference share shall be redeemed within 20 years of its issue, except the companies engaged in the business of infrastructure projects can issue preference shares for up to 30 years. And as we have already discussed, from the 21st year, they have to start redeeming at least 10% value of the shares. So the preference shares can be redeemed only out of the profits of the company or the proceeds from the issue, fresh issue made for the purpose of redemption. Only fully paid up preference shares can be redeemed. A company needs to create an account called capital redemption reserve accounts, and which needs to be maintained by the company with an amount equivalent to its nominal value of shares for the redemption of preference shares out of the profits. If the company is redeeming the shares at premium, So before redemption, premium amount shall be paid out of the profits of the company or the securities premium account of the company, and then the redemption of the preference shares shall be done. Preference shares cannot be redeemed at discount. And if there is a situation wherein the company is unable to redeem the preference shares or pay the dividend, then with the consent of the 3/4 preference shareholders of value and along with the application to the NCLT, company can issue further redeemable preference shares equivalent to the amount of the unredeemed preference shares, including the dividend which has not been paid, and for the same amount, they can issue the further redeemable preference shares. So on the issue of the further redeemable preference shares, the unredeemed preference shares shall be deemed to have been redeemed. While giving the approval, the tribunal shall order the redemption forthwith for the preference shareholders who have not consent to the issue of further redeemable preference shares. Those shareholders, if should be not more than 1/4 of the preference shareholders, if they do not consent that their share to be further redeemable preference share would be issued in lieu of the existing preference shares, then their redemption needs to be done mandatorily by the company.
Yeah. Yeah, Sakshi, there are a couple of points I think for redemption that we can deliberate upon. One is timing of redemption. The preference shares are contractual instrument, and whatever we have contractually agreed, maybe it is tenure of 1 year, maybe it is tenure of 3 years, maybe it is 5 years, anything which is within the framework prescribed by the law, that is 20 years or 30 years as the case may be. Within that tenure, whatever contractually we have agreed, we will abide by that, right? So it may be any term on which, or it may be also on happening of particular event. Many a time we are not prescribing a tenure. We are saying maximum tenure is 20 years, but the redemption will be done on happening or not happening of this event. Or if suppose they say that if you are not able to raise the turnover of a company beyond a prescribed number, let's say 1,000 crore, number is not achieved by 2030, then the redemption will take place on the 31st March 2030. Now, so it could be conditional on happening or not happening of a particular event, or it can be at the option of the company, or it can be at the option of the shareholder, or it can be at a fixed tenure as contractually agreed. This is the first point. Second point that we should consider, the preference share redemption can be made out of two things. One, profit which is available for distribution as dividend. And please understand, the amount that is transferred to reserve is not the profit which is available for distribution as a dividend. In terms of provisions of section 123, there is a very clear distinction with regard to declaration of dividend out of surplus available in the profit and loss account and declaration of dividend out of reserve. You will appreciate that the declaration of dividend out of reserve rules had put certain condition, and the conditions are that you should have declared dividend in the past, right? And the average should not exceed so and so. You cannot withdraw more than 15% of the amount. The after withdrawal, the premium account should not be, the reserve account should not be falling below a prescribed percentage. So I am not of the view that we can use the reserve, because in any which case you have already parked that amount to one particular reserve. You cannot touch and you cannot withdraw the amount unless the specific process is followed. So only and only if you have a surplus available in your profit and loss account, you can use that surplus for the purpose of redemption. That is very important point that we should keep in mind. Whether it is a surplus available in your profit and loss account or whether it is a reserve available in your profit and loss account for the purpose of redemption. Second option is I can issue fresh shares. Fresh shares could be equity or fresh shares could be preference share. Preference shares could be redeemable preference share or they could be convertible preference share. There is no restriction. I can use any kind of instrument for the purpose of issuance of these securities for the purpose of doing a redemption. Now, one more condition that we should keep in mind is whether the company is required to comply with Ind AS provision. If a company is subjected to Ind AS provision, the premium which is payable on redemption has to compulsorily come from surplus in the profit and loss account. For other companies, the flexibility is the premium, if any, payable on redemption of preference share can come from the securities premium account also. Or if you have the instrument subsisting, that is when on 1/4/2014 you transited to the new Companies Act, at that point of time there was a company who has issued the preference share for tenure of 20 years. Let us say on 1/4/2013 they have issued the preference share for a 20-year tenure and they are subsisting. So those maybe Ind AS is also applicable, but still you can use the securities premium account for the purpose of redemption of preference share and payment of premium, right? But otherwise, the Ind AS applicability will stop or restrict you from the usage of securities premium account for the purpose of payment of redemption premium. Let us understand it from the clarity perspective by having one example. Now, let us assume there is a company ABC Limited which has issued 1 crore 6% redeemable preference share at a face value of rupees 10 at a premium of rupees 10 each on April 1, 2020. So how much capital you raised? You raised the preference share capital of 10 crore. You raised the premium of rupees 10 crore. Now assume that the tenure is for the period of 5 years and they are supposed to be redeemed on or before 31st March 2025. On 31st March 2025, your premium account is 10 crore and your surplus in profit and loss account is 20 crore. Assuming that. Now, if your company is ABC is subjected to Ind AS compliance, can you redeem the preference share at a 20 rupee premium? Now, if you are redeeming the preference share at a 20 rupees, that means you require premium payment of 20 crore and 10 crore par value. That means you require total 30 crore. Now you have currently 10 crore of premium and 20 crore of surplus in the profit and loss account. If Ind AS is applicable, securities premium account cannot be used for the purpose of redemption of and payment of premium. So you have left with only one option, that you redeem these preference shares by issue of fresh equity or preference share. But you cannot use your premium and surplus for the purpose of redemption, because premium amount cannot be paid off by the by the reserve account. If you are not Ind AS compliant company, if your Ind AS is not applicable, then very well you have a 30 crore available in your kitty and you want to make redemption for the purpose for premium, you can pay from 10 crore from your premium account and 10 crore from your surplus in profit and loss account, and 10 crore par value can be paid from the surplus in PL account. 30 crore will be paid and the preference shares can be redeemed. Alternatively, you can also use the issue of fresh security for the purpose of redemption. One point which we parked earlier with regard to the subsisting default, I would take a minute to clarify on that also, and then Sakshi will proceed further. Now, whether we can issue preference shares for the purpose of redemption of earlier series of preference share is a catch point. And suppose this ABC was in default and the terms of preference shares were cumulative. Because what I understand, for subsisting default, the preference share compulsorily had to be cumulative in nature. Because if they are non-cumulative, what will be happening if I have not declared dividend for 2021? All right, there is no accumulation for 21-22. I can still pay and my default will not be subsisting. I have paid and chapter ends. But if it is cumulative, my default will be good if I have not paid in year 1, year 2. In year 3, I will pay cumulative amount. Right? So in regard to dividend, the subsisting default indicates that the preference shares are cumulative and the company is not in a position to make the payment of dividend. As far as the redemption is concerned, whether you are cumulative or non-cumulative will not make any difference. So suppose the company was supposed to make the redemption on or before 31st of March 2025 and company fails. And now after company fails, the subsisting default will continue. So after 31st March 2025, when default has already triggered and is subsisting, you cannot redeem these preference share by issuing another new series of a preference share. This is a very important point and missed out by many when they are issuing and designing the instrument. However, if you propose to raise a capital before you end up into default, that is prior to 31st March 2025, let us say on 1st of March 2025, you are issuing another round of preference share because there is no default as of now with regard to redemption. You are not stopped from raising the capital by issuing the preference share. Otherwise, you will be stopped after 31st of March because the default will become subsisting. There is one more point. What is the difference between redemption under 55(2) and redemption under 55(3)? There is a hell lot of difference. When I am using 55(3), which is with tribunal approval, there is no cash flow. No cash comes into the company and my tenure of the preference share increases as per the directions of tribunal. Whereas when in 55(2), I am making redemption of preference share by issue of a new preference share, a cash flow is mandatory. That is, new preference shares will be issued against the cash flow from the investor. Whereas in 55(3), no cash flow, you are in default, you went and filed the application to NCLT, and NCLT will allow the issuance of preference share to the existing preference shareholder. In a way, your tenure will increase. Suppose your tenure was 10 years, now NCLT ordered, and the tenure could be another 10 years. So and mind you, this tenure can extend beyond even 20 years. So your tenure was 20 years. After end of 20 years, you are not in a position to redeem. You filed the application before the NCLT, and NCLT says, all right, we are allowing the issuance of redeemable preference shares to the existing preference shareholder for another period of 5 years. So your tenure extends to 25 years in a way, but there is no cash coming into the company. When I do a redemption under 55(2), it is compulsory that the cash will flow into the company. That is the crux of the matter when I am saying the difference between 55(2) and 55(3). I think by and large I have covered. And one more point I think which is very important. When I am doing a redemption out of surplus available in profit and loss account, it is compulsory to create a capital redemption reserve of the equivalent amount of the face value, not of the premium amount. This is to ensure that your capital reduction does not trigger. Otherwise, what will happen? Suppose you have a preference share capital of 10 crore and you redeem, your capital mismatch will create. So profit and loss account will be debited and capital redemption reserve account will be credited. Your balance sheet will remain same. Whereas if you are making redemption out of issue of fresh equity or fresh preference share, there is no requirement of creation of capital redemption reserve because new capital will replace the existing capital. So your capital remain intact. That is the fundamental. I think we are by and large done with redemption. We can take some questions or maybe we can take little later.
Amit, somebody is asking you, can an index supersede the provision of the Companies Act regarding the payment of the premium in the redemption of the preference share?
No, where it is superseding, the law itself provides, the law says, I think confusion comes from section 55(2), which says that for a class of companies and which are on which the provisions of Ind AS are applicable in terms of provisions of section 133. Now, somebody will try to find out that under Rule 9, there is no class of companies prescribed. Class of company has to be inferred from the provisions of section 133, which talks about the applicability of Ind AS. So for Ind AS applicability, the class of companies has been prescribed in the rules made under the Ind AS rules. So you have to see those class of companies on which the Ind AS is applicable. You have a restriction with regard to using the securities premium for the purpose of paying the redemption premium. For other companies, you can continue to use your securities premium for the purpose of redemption premium payment. There is no conflict as such.
Yeah.
Amit, one more thing is there. If I go through your
Tushar is asking, sir, just a minute. Tushar is asking Ind AS number. So there is no Ind AS. Ind AS is not putting any restriction. The law says if Ind AS is applicable, the law of redemption would be so and so. That's it.
So basically, the kind of company to which index is applicable, they can't use.
Correct. It is not that Ind AS is putting any restriction on redemption or payment of redemption premium. It is Companies Act 55(2), which is saying if Ind AS is applicable on you and you are a class of company on which Ind AS is applicable, then you can't pay the redemption premium from your securities premium account. No Ind AS is putting any restriction. It is only referring to class of companies on which the Ind AS is applicable.
That means short point is it is a company law provision, it is not the index provision. As he puts
Absolutely.
it, whether
Yeah.
index can supersede, that answers the question. It is a company law provision, it is not the index provision.
For identifying those class of companies, it is referring to the companies on which the Ind AS is applicable. That's it.
Okay. Amit, I got one thing to get it clarified. When we are saying irredeemable preference share, and the period is 20 years or 30 years, whatever it is, depending upon infrastructure company, non-infrastructure company. When we say they can actually issue a fresh issue, they can redeem it. Isn't it in a way the preference share is actually acquire the color of the perpetuity in continuing? Every time you reissue and you again, you issue the fresh share,
So
isn't it?
idea is, I'll explain. So if you see the J.J. Irani committee recommendation when the Companies Act 2013 was getting crafted, the committee was of the view that we should do away with the restriction with regard to, and we should bring the concept of perpetuality of the preference share, irredeemable preference share. Then they said, no, this may not be correct. Let us continue with a window where the investor should be given the option to decide what they want to, right? So if investor, what will be the case? Suppose there are A, B, C investor who have invested in the preference share capital of a company, and 20-year tenure is now coming to an end. Company coming out with the fresh issue of a preference shares which are redeemable for another 20 years. There are two possibilities. One, A, B, C investors have a confidence in the company and they want to continue married with the company, and they will give another round of preference share subscription. So they will be increasing their tenure in a way, right, by infusing fresh round of capital. But generally what will happen, instead of ABC, there will be another set of investor PQR who will be now bringing the capital into the company, and they will be replacing ABC. But fresh capital will be introduced. This is without intervention of NCLT. If you want further tenure to be increased without bringing a capital, you have to compulsorily go to NCLT and let NCLT pass the order for increasing the tenure by issue of preference share, where no new capital will be infused, but that is a special condition. You have reached out to the regulator, you have reached out to the adjudicating authority for increasing the tenure when you are not in a position to make the redemption. So in a way, it is a kind of giving a leeway to the companies where investors have a confidence in continuing, or a new investors are available for the purpose of continuing in the company as a preference shareholder. So in those cases only you
Thank you.
can
Go ahead,
continue,
Sakshi.
otherwise you have no option but to redeem during that particular period of time. So irredeemable preference shares are out from the concept. They are out, in fact, from 88 itself.
Yes,
Yes,
sir.
Sakshi.
So now we have completed the provisions of issue and redemption of preference share under Companies Act 2013. However, the listed companies are required to make certain additional compliances with respect to the issue of preference shares or its redemptions, but it would be very similar to the disclosure requirements which has been done in normal course of business, or the prior intimation to the stock exchanges under Regulation 29, which is like advance 2 working days notice to the stock exchanges, needs to be done. Under Regulation 30, the disclosure with respect to the board meeting, the scrutinizer reports, any information with respect to the issue of the securities, which has been given under Schedule 3 of LODR pertaining to the issue of security shall be mandatorily complied by the listed entities for the issuance of preference shares, and other compliances and disclosures pertaining to the record dates and mentioned under Regulation 42 of LODR shall also be considered while making issue of preference shares. So that's it from my side for the issue of preference shares. Now we can take the questions.
Yeah, we'll do that.
Stops. I said, don't leave it sharing because people may ask the question related to those slides. Yeah. Mr. Bala, you can take.
Yeah.
No, you can keep last slide, but don't close the PPT.
I think one
Sure.
point, Sakshi, we have missed out to deliberate. Rather, 2 points. One, I think I'll deliberate on those 2 points and then we can take up the.
Sure. Go ahead.
One, I think there has been a difference in the preference share provision from 56 Act to 2013 law. And one, with regard to voting rights of the preference shareholder, though Sakshi has touched upon very briefly, but I think these provisions deserve little more discussion and deliberation. So if I can just indicate the provisions with regard to 1956 with regard to the voting, I think general voting right was provided in section 87(2) of the 1956 Act, and the general provision says that the preference shareholder will have a right to vote on any resolution which directly affect the rights attached to the preference shareholder. Now, so if I want to change the coupon rate, if I want to change the tenure of redemption, convertibility, pricing, all these affect the right of preference shareholder, and preference shareholder will get the right to vote on that particular resolution. Or if a resolution pertains to winding up of a company, or it pertains to repayment or reduction of share capital. So these are the three agenda which were there in 56 Act on which the general voting right was available to the preference shareholder, and more or less same provision in the same language continues in the section 47(2) also for the preference share. And preference share voting right will always be in proportion to the total capital of a company. That means you will calculate the preference share capital pro rata to the total capital of a company, equity plus preference, and that's how the voting right will be decided. Now, 87(2)(b) of the previous law, that is 1956 Act, was little different than what we have today. Let us see what we have today. Now, presently, the specific voting right on all resolutions will come when the dividend in respect of any class of preference share has not been paid for a period of 2 years or more. Very simple language. What it says, when the dividend in respect of any class of preference share has not been paid, it has done away with the concept of whether it is due or not due. Now, here we are parking one point as to when the dividend will become due. That we are parking for a moment. Let us see what was the provision in the 56 Act. 87(2)(b) was dealing with voting right on the preference share on all resolutions, and it was having a distinction between cumulative preference share and non-cumulative preference share. For cumulative, it was saying कि if a dividend due on preference shares has remained unpaid in case of a cumulative preference share for period not less than 2 years prior to commencement of the meeting. So if meeting commences today, prior to this, that is on 7th of February 2025, 2 years period has completed and the dividend which has been due has remained unpaid. If it is the non-cumulative, then the period calculation is little different. It is relating to the financial year period, that is 2 years period prior to this, that is we are on 7th of February, 8th of February. Prior to this, the immediate previous financial year is 31st March 2024. So default was in respect of 31st March 2024 and 31st March 2023. Then the default will be considered. Or out of 6 years, there has been default into at least 2 years. 3 out of 6 or 2 immediately preceding financial year. That was the condition in which the default was considered and the voting right on all the resolution was triggered. Now, interesting is the word due and the explanation to section 87(2) was there, which was providing how and when you will consider the dividend becomes due. Answer was very simple and it was saying whatever contractually you have agreed on the last day, whatever has been specified for the payment of such dividend or in the article or in the instrument, whatever has been agreed. So your terms and conditions of the issue provide your dividend will become due on 31st March of respective year. So your dividend, if not paid by 31st of March, will be considered. Or if your article says the terms of preference share shall be so and so, that dividend will become due and payable on end of the respective financial year. So that will be the date. Or if there is no date specified, now there could be situation that no date is specified, that the day following, suppose instrument is issued on 31st of March 2024, the dividend will become due on 1st of April 2024, the day next following. So depend on the wordings in your contract or in your article, or if nothing is specified, the day following the next day. That was the provision with regard to dividend default and the voting right trigger. Now, how to read the new law? The new law is very simple. New law does not make any distinction between cumulative, non-cumulative. It does not talk about 2 consecutive year. It says 2 years. I have issued the dividend. I have issued the instrument in the year 2020, and I have remained unpaid for any 2 year during the tenure of that particular preference share. The default will trigger and voting right will come to the respective preference shareholder, whereby he'll be entitled to vote on all resolution. And as regards the period when it will become due, right? Because now there is no condition that it should be becoming due and then, but analogy remains the same. I think we can follow what was provided in the old law, though the word due is not there, but how you will consider default. whether it has become due or not become due, you will always consider it as a default, either whatever you have provided in the contractual. So by changing this, I think law has given you little bit of freedom how you can define in your contractual document as to when the dividend will become due and payable, right? Depending on that particular date, the default will actually trigger and the voting right will actually come on the particular person. Second difference, if I talk about the difference from the 56 Act to the 2013 law, one difference is with regard to the tenure of 20-year versus 30-year, and redemption difference is also there that we have seen. Ind AS provision has been introduced. Other than that, the issuance of security has also undergone a significant change with regard to section 80 versus the provisions of section 55 read with 42, 62. I think they have aligned it now in a holistic manner as to what terms the terms and conditions the securities can be issued. I think Bala sir, I'm done with the
1 minute, huh? Amit, you can touch upon, because generally this question will be asked, that if equity dividend is not declared for 2 years
yeah.
and the preference share is cumulative, if non-cumulative, no question, then whether after 2 years the preference shareholder will be entitled to all rights?
Now
Like,
I'll go to one extent further. I'm saying earlier there was a difference between cumulative and non-cumulative. Now there is no difference between cumulative and non-cumulative. This is first difference. Second difference is earlier there was a word due. Now there is no word due. It is a paid. If you have not paid, whether it was due or not, whether it was cumulative or not, the voting right will trigger irrespective.
right.
Whatever be the situation, right? So voting right will trigger. Now, from planning perspective, if I am a private limited company, which startups are usually, how they can safeguard their interest while issuing the preference share as an instrument. A planning could be that I make a alteration in my article to provide that no voting right will trigger to the preference shareholder, irrespective whether the dividend is paid or not. Whether the provisions of section 43, 47, and we can specifically say provisions of section 43, 47, notwithstanding anything contained in 43, 47, the voting right on the preference share in any situation whatsoever will not trigger on all resolution. I think with this, you can avoid the trigger of voting right and you can avoid the losing the control to the preference shareholder when you are not in a position to pay the dividend. I think that's the planning perspective. Yeah.
Dipti, that means, if you recall it, we actually started the very first session, the Masterclass of Companies Act, where we talked about the definition and the drafting of article and memorandum of association. So Amit very rightly touch upon how professional can actually play a role in putting and drafting the right perspective when we incorporate the company. Yeah.
Absolutely. I think bang on means for a private limited company, for a public limited company, drafting an article is not a craft. But for a private limited company, drafting an article is certainly a craft, and you should invest time and money as well in getting that particular document drafted to suit to your requirement so that you can create a situation in your favor as and when it is called for.
But Amit, that can be the question, that whether you can write in the article that this section provisions will not be applicable to my security.
Yeah, 5th June 2015 notification has created a carve out in respect of certain provisions, and including 43, 47, it says that the provisions of section 43, 47 will not be applicable on a private limited company if specifically provided in your article. So you have to, of course, there is one more provision that you can't create these kind of exceptions which are against the public interest of the general shareholder, right? So you have to be little mindful, but yes, it is possible.
Again, Dipti, another thing which comes into the mind is right interpretation. Reading and interpreting the law, that also comes into the mind. Yeah.
Yeah.
Okay, we'll start with the questions now.
Yeah, please.
Can the preference share be redeemed out of the issue of the right issue of the equity share?
Yeah, we can issue what mode you are using for the purpose of issue of security. The law is very clear. You can redeem the preference share out of surplus available in the profit and loss account or out of issue of fresh shares, right? Whether fresh share is issued by rights issue or it is issued by private placement or it is issued by preferential allotment. Does not matter. Whatever route you want to take, you can take, and redemption is possible.
Can we actually convert one class of the CCPs into another class of the CCPs? If yes, whether we need to go by the scheme of arrangement?
One class of CCPS into another class of preference share can be achieved by following the provisions of section 48, variation of shareholders' right. I think Shakshi has touched upon that very well, and there is no difficulty. You need not go for a scheme of arrangement. A scheme of arrangement is not required for changing the what terms you are changing. Maybe CCPS was for earlier 10-year tenure, coupon rate was 10%. Now you want 6% coupon rate and you want tenure of 15 year. After which, or maybe put or call option you are changing, exchanging, right? There could be other things also, but I don't see any reason as to why we need a scheme of arrangement to change the one CCPS into another kind of CCPS. It is possible.
Does company newly incorporated have a class of the preference share issue? If yes, under which article of association?
So, sorry, sir, please come again.
It's it
Does company newly incorporated have a class of the preference share issue?
is said that in a newly incorporated company article, the preference share issue provision is required. If yes, then under which article of it?
No, so it is your choice. So if you are incorporating a new company under the Companies Act 2013, it is not mandatory to have a preference share capital, right? But if you decide that you want to have a preference share capital, then you can have an enabling clause in your memorandum and article of association with regard to the issue of preference shares. But if you don't want, it is not mandatory. But if you want to have from day one, you can have it from day one. But only condition is that perhaps you cannot incorporate, you cannot have a only preference share capital. Compulsorily, you will have at least one share towards the equity also. Now, so only preference share capital cannot be used for the purpose of incorporation of a company. Equity is mandatory. In addition, if you want to have a preference also from day one, no restriction.
Rajshri is actually putting up a comment here. The
Skip.
basic preference shareholders, equity shareholder is just like a
Yeah, Bala.
MP.
Yeah. Next.
Okay. How will the valuation be done in CCPS considering they will be converted years later? I think you
I think
just
we have
answered this
answered.
question. We discussed
Yeah,
this.
we have discussed now.
13(2)(h) has to be followed, and as I mentioned, I am repeating again, the preference share value is in respect of underlying equity shares in which it will be converted. Always the valuation is of equity in which the preference shares are going to be converted. If they are not convertible, there is no valuation requirement. Valuation can be opted at the time of issue of preference shares which are convertible or at the time of conversion.
Can a preference share not be both redeemable and optionally convertible?
Yeah, it will be essentially be optionally convertible. OCPS is a very common instrument where the company can have an option to convert, or the preference shareholder can have an option to convert. Option can be put or call option can be with either.
A public company has issued 5% optionally convertible non-cumulative redeemable preference share in 2017. However, dividend of 5% not declared and paid till date or any year is actually mandated to dedicate any dividend. Further, as per the Section 4 of the Companies Act 2013, wherein the dividend has been declared for the period of 2 years or more, such class of the preference share shall have a right in the voting right at all the resolutions placed before the company. In such whether preference share shall participate in voting of AGM and EGM, everything.
Yes,
Yes,
absolutely.
yes, we discussed that. Yeah.
Whether the company can issue the preference share at a premium and redeem it at par as no pricing required.
Now, question is, I have issued the preference share at a premium and I want to redeem at a par value. I don't see that there is any difficulty in doing so. It is very well possible, but income tax may have a different view on this particular subject from the standpoint as to why any sane investor would agree upfront, wherein they say that I'll pay you 100 rupee, you pay me only 10 rupee, and I will redeem. So they may look from a different angle, and the transaction may look little fishy from the black money perspective. So you need to be little cautious. Otherwise, legally, I don't see that there is any challenge. Yeah, preference
Zero,
shareholder will be entitled to AGM notice if voting right has triggered, or even
zero,
if yeah.
0.00 dividend or nil percentage preference share can be issued.
Now, this is very interesting question. I was expecting that this question. Yeah. Now, if you ask this question, I think we need to go to the provisions of section 43, which defines kind of share capital. Now, kind of share capital includes equity and preference. Now, how the preference share capital has been defined is provided in section 43. And let me just open that 43 also so that I can tell exact language which is used. So 43 explanation says preference share capital with reference to any company limited by share means that part of the issued share capital of the company which carries or would carry a preferential right with respect to A, payment of dividend, B, repayment in case of winding up, or repayment of capital. That means the preference shareholder essentially has two rights. One, a preferential right to get a dividend, a preferential right to participate in the surplus while winding up of the company. Now, interesting point is the word which is used in between these two conditions, that is and. The adjective is and. How you read this adjective will decide whether you can use this or not. If I say that this and has to be interpreted strictly as and only, then both of these conditions are mandatory. That is, a preferential right to dividend and preferential right to receive the capital back. If both of these rights are mandatory, then somebody can say you cannot issue zero coupon, because Zero coupon means I don't have any preference. The equity shareholder, whenever are going to be paid any dividend, the preference shareholder not be given any special consideration. Then what preference I am getting? This is one view. If I am saying this and has to be interpreted as a and only, but if you see certain provisions of statute, interpretation of statute, and the judgment of Supreme Court, where it says in certain situations this word and has to be interpreted as or, the situation changes, and the situation would be preference share capital may have either of the character and it will be considered as a preference share. One of the characteristic is that I should have a preferential right to receive the dividend, or I should have a preferential right to receive back my capital. If either of the feature I am having in my preference share capital, still it will be a preference share capital. So that means my coupon rate still is 0, but I have a preferential right in receiving back this capital. So whenever the equity will be paid back their capital, prior to that, I will have a right to get back my capital. And depending on these two different interpretation, there are two school of thoughts which are going on in the market. And you will see many of the listed company examples as well who have issued zero coupon preference shares. And you will see many of the unlisted entities also coming up with the zero coupon, and so far this issue has not been challenged before any forum. As an academician, we can deliberate, we can continue to discuss, we can debate, but these are the two sides of the coin which I have presented, and basis that propaganda of the respective views, they are supporting their thoughts and they are supporting their stand, and they are taking their call basis that only, I think.
Amit, I have seen in some of the companies preference share issued actually 0.0001%.
Yeah, it is. So I am saying I have seen many of the companies where it is zero coupon. 0.001 is like I have some preference, right? Maybe it is 0.000001%. All right. Still, it meets the condition of and.
No,
Now,
instead of saying a zero, they are just putting 0.1 for the namesake.
Yeah, that same thing is telling. Still, it is 0.1 also is a.
Yeah, that is right.
howsoever
That is right.
small, it is a preference and it meets the requirement, right?
Yeah.
The other school of thought says this and is nothing but has to be interpreted in line with the Supreme Court judgment that this and is or actually, right? This has to be interpreted as or, and they are saying ki I am in my right, correct that I will issue the zero coupon also because I have a instrument where I am saying ki you have no right to preference to the dividend, but you have a right to participate while winding up at the priority. So that is how it is being interpreted.
While issuing the optionally convertible instruments, what factors to be considered while deciding between the OCPs and the CCPs?
No, sorry, sir, I missed out. Can you come repeat again?
Yeah, while issuing optionally convertible instruments, what factors to be considered while deciding between optionally convertible and compulsorily convertible?
I think I have discussed this in detail. OCPS, CCPS, from company standpoint and from the investor standpoint, I think those are the only factors which are required to be considered in mind. OCPS will be from the company standpoint, will be a weapon or will be useful in those cases where you are not sure about the future potential of your company, right? You are retaining that whether you will be having a cash flow or not, right? So you are saying that tomorrow if I have a cash flow, and I don't want to dilute my capital. I will pay them back and I will enjoy the 100% of control over my company, right? And if I say that tomorrow, I don't know, maybe I will be in a position where I don't have a much growth and my cash flow will not permit me to pay back the or redeem the preference share, then I will be diluting my equity, right? So I will opt for the conversion. So in these situations, OCPS will be useful. That's
I
how.
think we discussed, yeah, in quite detail. We can go to next.
Okay. I understand that the issue of the
No, there is a question. Can company have unclassified authorized share capital?
yeah, can
Yeah.
company have an unclassified authorized share capital?
Not possible as of now. Under the new law, specifically when the EMOA concept is there, now it is not possible. You cannot have unclassified authorized share capital. You have to classify.
I understand the issue of the OCTs will be attract deposit provisions apart from the
OCD
compliance
take.
issue.
OCD
What
don't
other
take.
yeah,
Ms. Mala, OCD don't take. Take next.
Okay. Okay. I have a situation where the article of association not been actually participating, authorizing the issue of the shares. The issue of the preference share was authorized by the special resolution under section 62 and 42. When I actually flagged the issue for the difference given, that was actually given the special resolution is passed for the issue it. Is also deemed authorization in the article of association. Request your views.
I think this is the question from Karthik sir, and what he means is perhaps as Sakshi was mentioning, and in terms of provisions of section 55, you need to have a special resolution passed for issue of preference share. So company has not passed under section 55. It is a, I think, error in mention of the provisions of the relevant section. Instead of 55, they have unquoted the provisions of section 42, 62 for the purpose of issue of preference share. I don't see in any way it is going to be challenging as far as the issue of preference share is concerned. I have read one of the article of Dr. Chandratre, where he has very categorically mentioned that just a mistake on the part of the company or non-mention of a relevant provision of the section will not defy the very purpose for which the resolution was passed. The objective underlying was that the approval should be by way of a special resolution, that is the vote casted in favor were 3 times more than the vote casted against. So as long as you are able to confirm that all relevant disclosures were made, all relevant provisions are complied with. So if you have not mentioned, even I think there should not be any problem. If I have understood correctly the question which has been flagged.
Can you avoid repeated ISIN in future allotments? Can
Yes,
you
sir.
repeat the same point what you
He
explained? Yes,
repeated
asking you.
also. Yeah, he repeated also that time. Yeah.
But I think we will require Chandrasekhar to be unmuted maybe at the end because I think he wanted to say something. And
Yeah, yeah. We will allow at the end a raise of hand, no? That time. We will
Okay.
quickly go through now all the questions.
Okay. Then again, it is how to avoid.
Jivika also has same question. Yeah.
Then again, how do we get the initial ISN in the preference share and use them for the same ISN? I think
We
more or
will
less it
take
is
up
pertaining
this
the
same
same.
question at the
Yeah.
end.
Can the variation be made with regard to the what is that? With regard to the
Rollover,
rolling
that is increasing the tenor
Acha.
of redeemable preference shares by say from 5 years to 10 years if 3/4 of the holders agree in writing without going to NCLT.
Yeah, possible.
Possible, we discussed the variation
Yeah,
of
you actually discussed it. It is a contractual right. It can be done. Yeah.
Variation in
that-
shareholder right has a very enabling power. Under section 48, you can do such kind of variation. There is absolutely no difficulty. It is only when you are not in a position to redeem and you want, and perhaps your 20-year tenure is over, right?
Oh.
And now you have no option but to go to NCLT, then section 55(3) will be triggering.
Then you have to go to NCLT, otherwise.
Yeah.
If the company has no profit and is incurring losses, as such, unable to issue the fresh share, how the redemption of the preference share shall happen?
No option. You have only option to invoke 55(3).
Then the next question, can entire supersede? I think that we discussed actually. Company is under AS, 0.1% convertible redeemable preference share issued, and the company is having continuous losses. What is the way to redeem the preference share?
You can issue fresh equity or fresh preference share and then redeem. That is the only option, because you don't have a profit available for the purpose of redemption. That is the disadvantage. And many a time when we are doing a planning, we don't envisage what is the cash flow likely. Like if you don't envisage that in a correct manner, you are going to be in trouble. Preference share is a very good instrument, but if executed, if planned, if not planned, it may create a lot of havoc in the capital structure of a company. So you have to be very mindful when you are planning the instrument.
Because it is a, as you say, it's a have a color of debt also. That we should not forget. Yeah.
What is the consequences that the profit-making company, limited company, is not paying dividend, paying for the last several years since issue of the shares? They are not paying the dividend on equity also. Is there a difficult on preference share? Is this can be a redeem these preference share without paying the dividends?
So if it is non-cumulative, you can redeem without paying the past dividend. There is no issue. As far as voting right is concerned, that is very clear. Whether you have a profit, whether you don't have a profit, voting right will trigger, right? Now, only one thing I think we missed out in discussion is whether the preference share dividend is required to be declared by the board, right? It is a contractual right, but yes, the declaration is required. Even though I have a profit, but I may decide not to declare. Now, can this power of declaration be delegated to a managing director of a company? Answer is yes. There is no difficulty. The rate is already decided. Coupon is decided. I can delegate that managing director of the company can make assessment of the financial position from time to time and declare the dividend on the preference share. And if declared, it will be paid as the case may be. So there is no difficulty. And last point, the dividend on the preference share being contractual in nature is not required to be ratified by the shareholder at their general meeting. This is not a dividend per se in terms of the provisions of section 123, and the provisions are not applicable that you need to ratify, because what if they don't ratify? That means you whatever you have done is going for a non-compliance. No, that is not intended and that is not required.
Amit, but the thing is, the dividend is actually going from the, appropriation of the profits, because it is going from the profit from declaration. The
But
declared the profit is actually given to the right to the shareholders. Don't you
all
think
right,
it should be
I will,
declared in
I
the
will,
AGM?
I will answer that, because 55 envisage the approval of shareholder by way of a special resolution. So at the very time when you were issuing, you have placed the matter before the shareholder for their approval. Shareholders have already agreed the contractual terms with the investor that the investors will be entitled to the 10%, 6% of the coupon rate at a fixed tenure, right? So there is no necessity that every year, in case of a normal dividend, there is no such condition. Coupon rate is not decided on the equity. So for equity, you need to go to recommend the dividend and shareholder will declare. But in case of a preference share, since everything is beforehand decided and contractually approved, this is not required to be declared at a shareholder meeting at all.
when the new shares are issued for the redemption of the share capital is actually created when the money is received. What is the accounting treatment, and will there be any mismatch in the capital account?
No, there will not be, Chandrasekhar. There will not be any mismatch. So, new share capital account will be credited, cash will be coming debited, and when you are making repayment, your cash account will be credited and capital account will be debited.
After issuing the preference share, when will the creation of the CRR trigger?
After issuing preference share, no. CRR is created only when you make redemption of preference share out of profit. If you don't make redemption out of profit, you make redemption out of issue of fresh preference share or fresh equity, no CRR is created. Please understand the concept. To avoid the fatal consequence of reduction, in case you are redeeming the preference share out of profit, a CRR is created so that the balance sheet can remain same. It can tally. If you are doing by issue of fresh equity or fresh preference, new equity will replace the existing equity and capital again will remain same. So there is no reduction in either of the cases. So that's how we have to understand.
So no, but the question what is asked is at what time CRR should be, at the time of issue
At
or
the same time, at the time of redemption.
Yeah, that is the question actually.
Yeah. At simultaneous
55,
1 minute. Yeah.
simultaneous entries are made. See, I think many a time the problem is that people don't understand the utilization of the accounting entry and the cash entry. Preference share involves both entries. There is a cash payout. Your cash account or bank account will also be hitted, and your accounting entry will also be hitted. Your accounting entry is your profit and loss account will be debited and capital redemption reserve account will be credited. This is one entry. On the other hand, your capital account will be debited and your cash account will be credited. Bank account will be credited and the respective shareholder account will again be adjusted along with that. Yeah.
55(2)(d)(I), in case of the such clauses of the companies as they are prescribed and whose financial statement comply with the accounting standard. Acha, this is the information he is giving. Whatever you said, actually.
I think Maheshji, we need to unmute Maheshji also at the end because I think he has flagged that point which Ind AS he's talking about. I'll clarify because 55(2)(d)(1) Roman is very clear in terms of its language because the confusion is with regard to the class of companies, right? I'll explain that, I think, once he unmute.
What is the nature of the coupon rate attached to a category of the preference share for a class of companies for which Ind AS is applicable as dividend? I think this you are going to discuss, I think.
No, it is same. It is a dividend only, and preference share, whatever you decide as a coupon rate will always remain as a dividend. It will never be considered as an interest. It is not charge in your profit and loss account. It is appropriation only. You can't claim it as a deduction under your business expense, right? It is appropriation. But yes, it is a contractual.
Can a company issue 0% OCPS? I think this we have discussed. 43, 47 may be skipped in case of the private company subject to 2017 notification filing the annual forms.
Yeah. I think it is the information from Karthik, sir.
Okay. Can we say valuation of the preference share will always be higher than the valuation of the equity share?
No, why we can say so? Valuation of preference share, again, I mentioned, though technically, if somebody asks me a hyper-technical question, can I have a valuation of a preference share? Answer is yes, I can have valuation based on what is the coupon rate, what is the redemption period, what is the marketability. But per se, preference shares are not valued. Preference share valuation in terms of the provisions of the Companies Act is only in terms of its convertibility and underlying instrument being equity. So you value equity and basis that the valuation of preference share is derived. So it is the same value what the equity is having.
Can a company issue preference share to its equity holders as a bonus issue under the provision of the Companies Act 2030?
Now, preference shares could be redeemable or preference shares could be convertible. Let us see both of the situation. If it is convertible, absolutely there is no difficulty. First of all, let us understand, can I issue preference share through a rights issue to the existing shareholder? My view, answer is yes, I can issue convertible preference shares on the right basis, non-convertible redeemable preference shares also on the rights basis. And same manner, I can issue even convertible preference shares on the bonus issue basis also. Now, if I issue non-convertible or redeemable preference shares on the bonus basis, what does that mean? It simply means over a period of time, these preference shares will be redeemed and there will be a cash outflow from the company. Will it be permitted or will it not be permitted is a question that I think somebody wanted to ask. I think if you see it from understanding perspective, majority of the companies whosoever have done so, I think Britannia is one which has been doing consistently for the last several years, but they have done it through the scheme of arrangement. I have not seen.
Even last year, I think TVS has done it, I think so.
But whosoever has done, I think they have done through scheme only because
Yeah, TVS has actually last year they had done with the scheme of arrangement. They issued the preferential bonus share, but it was done from the scheme of arrangement.
In earlier webinar also we discussed and we said that everyone is doing through scheme only.
Yeah. But I think long back in 2013 Act, I don't recollect the year. I think Sun Pharmaceutical also done it, but I do not know how, because that was the 1956 Act. But I do not know how they have done it. Very long time back, that was one instant, I think, when I was there as a company secretary. But here last year, I think they had done it with the scheme of arrangement. Even this matter was discussed earlier also, actually. Yeah. Can a debenture be issued, other loan raised for redeem the preference share?
So if it is a cash flow problem, no problem. You can raise the debenture to fund your redemption of preference share, but you should have a profit.
Can a company issue 0% optionally convertible redeemable preference share? I think we discussed this. If the RPS is issued new shareholders, then section 62(1)(c) to be complied. This requires special resolution of the valuation report. In this case, the valuation report required or not?
Answer is, whenever you are issuing preference shares which are convertible into equity, you will have a requirement to comply 62(1)(c) read with Rule 13, along with provisions of section 55 read with Rule 9, and the provisions of section 42 read with Rule 14. And the valuation will be required either upfront or it will be required at the time of conversion.
Is preference shareholders entitled to the AGM notice? Yes, this answer you already answered actually.
Yeah.
Can the variation be made in the increasing the tenor of the share under section 48 with regard to tenor, assuming that there is only two preference shareholders and both agree?
Possible.
Citing this.
Yeah.
Possible.
Okay. This is your Ruchika. I hope one client where I need to convert loan, if I get through the net worth premiums per share, which is actually coming up thousands, turnover is in lakhs, and company is also in the losses because of the finance cost. This type of the premium is acceptable or not?
I think this is convert loan. I think Mr. Bala preference issue question you take on the topic. This is a conversion of loan is there. We cannot at this.
Okay. When Act is mentioning and not, this can be interpreted as or. How?
Yeah, this is a debatable issue when we were discussing about the zero coupon possibility. So I am saying that there are two school of thoughts which are there in the market. I leave it to the participant to how they interpret. I'm not, because industry has not settled the view on this particular subject so far. The matter has not been subjected to any litigation. But yes, the proponent of different school of thought have their own argument.
We have issued CCPS with a conversion ratio of 1:1% fully diluted basis. So how do we actually shareholding pattern in MGT7 attachment? Are we required to show separately equity shareholders and CCP holders number of the shares and percentage, or do total equity and CCP's number of the share or percentage?
No, I don't think in shareholding pattern in MGT7 you recognize the voting right until they are converted, right? Maybe you will be having a voting right triggered because of non-payment of dividend. For that, if you want, you can add a separate clarification note. But as far as the MGT7 is concerned, you are not required to make it on fully diluted basis.
Can a company invest in the subsidiary company through the redeemable preferred share? Whether it can be treated actually investment in its redeemable nature.
Yeah, it will be treated as investment. There is absolutely no problem. 186 thread with section 179 will be required to be complied by company who is doing a investment, and the provisions of section 55 read with 62 will be required to be complied by company who is issuing the redeemable preference shares.
Can we reclassify preference authorized capital into equity authorized capital?
Possible.
Okay. Dividend on a preferred shares upon company management means that 0.1% is not a liability to be paid. Then it is arguable.
Company management means even 0.01% is not liable to be paid, then I could not understand the question exactly. Dividend on preference share means, I think she is making a comment on your point, na, ki companies are
Yeah, that's right. How the period of 2 years default is actually calculated from the date of the issue of the year of the AGM date. I think you discussed this elaborately.
Discuss this point, and again I am clarifying, it depends on the, especially after 1/4/2014. The point is that what is your due date for the purpose of payment of dividend? If by default nothing is provided, then suppose my instrument was issued on 31st March 2024, then my dividend will become due on 1st of April 2025. So this is first date, and second due date will be 1st of April 2026. So 2 years complete here. After that, if your EGM happens on 2nd of April 2026, then your voting right will trigger.
Whether the opening of a separate bank account required for the dividend of the preference share?
Not required.
Yeah, because it is a contractual obligation. Anyway, it is agreed to be paid. It is actually coming as a charge, so it is not required. Yeah. In case of the preference dividend proceed requirement, like opening a separate bank, it's the same question again. Okay. Is the creation of CRR mandatory in case of the listed companies also?
Yes, if you are redeeming from the profit.
When should the nominal value be credited to CRR in case of the redemption?
Nominal value only.
No, when is asking.
When is at the time of redemption? The moment you are making accounting entry, you have to do that.
Do we don't need to file SI7 for reduction of the capital upon the redemption of the preference share out of profit?
No.
For reduction of capital, you need not file, but for redemption of preference share will be triggering a filing of SS7 itself.
Can such a company issue preference share to the equity shareholders or bonus issue under the provision of the Companies Act? I think we talked about this. Okay. Next question. Next is actually thanks going to you. Just to clarify, then preference share can be issued through the bonus issue through the scheme only?
Yeah, that is what I am saying. If it is a redeemable preference share, issue of such instrument in a form of a bonus are done by way of a scheme. Rest all can be issued in my view.
Yeah, whatever people have done it so far in the recent past, everything is done from the scheme of arrangement only. I think so. Is it better that the preference share before IPO planning or any company to increase their net worth? How does it actually work? Since there is no inflow of the money to the company, what
So
is
it
the logic
depends.
creating a CRR during redemption? Can you please explain simple terms? How does it actually benefit to the company and what is the intention?
See, idea is I'll address first question first. Madhur is asking two question. Is it better to convert the preference share before IPO? See, it is your pure and pure internal call that if you want to increase your capital base, if you want to meet the eligibility norms with regard to minimum share capital, or if you want, if you don't want to dilute your equity, suppose preference shareholders are your investor and you don't want to dilute and they have a still a long tenure and maybe you are in OCPS condition where they can be redeemed also over a period of time. So the answer is not straight. It will depend on your structure, who is a investor in the preference share, and what is the likely requirement, whether you are in short of your capital or not. Depending on that, I think the call can be taken. The next question, what Madhur is asking, what is the logic? I think I have explained many times in today's session also. See, if you don't create, see, the requirement of creation of CRR is only triggered when you are doing a redemption from surplus available in profit and loss account. If you are doing redemption from issue of shares, no CRR is required. Right? Why? Because new share capital is replacing the old share capital and capital remains unchanged. But when you are doing a redemption from profit, your existing capital, let us say 10 crore, will wipe out to zero. So it amounts to reduction. That reduction is prevented by creating CRR. Right? And CRR can be used for the purpose of making partly paid shares fully paid up. You can issue bonus share. That's it. That is the purpose of having this kind of capital redemption reserve. There is no other purpose.
I think I
No, yeah, all questions.
with all the questions. Now I can see there is a hand is raised from Raj Garg. Raj Garg, you are there. You can unmute. You can speak. Chandrasekhar also wants to talk. Yeah, Magesh also wants to talk. Yeah, you can unmute any one of you. Chandrasekhar, Magesh, Garg. Are you there, Chandrasekhar? Can you speak?
Do they have an option to unmute themselves? So now they have.
Yeah, I'm speaking.
Yes, sir.
Yeah, good afternoon to all the panelists.
Yes, please.
Yeah,
Yes.
my question is, we can redeem the preferences either out of fresh issue of shares or out of the profits available with the company. Now, if both the situations can't happen because the company may be incurring losses continuously, and as a matter of fact, it is not feasible to issue the fresh shares, and at the same time, company does not have the profits available. So how to redeem the preference shares? Will it amount to a violation of the provisions of the Companies Act if the company redeems the preference shares in such a situation?
No, you cannot redeem the preference share in such a situation. The only option available, maybe you can explore the possibility of making a variation under 48 and you convert these preference share into equity.
No, that is not feasible now, because why the shareholders should agree?
No, sir, Mahesh sir, there is no possibility because you can't flout the provisions of law. The redemption is possible only out of two. One, either profit available in surplus and profit and loss account or out of fresh issue. If you are
So then
not in a position,
it's a practical problem actually.
I
In
agree.
such a situation,
Yeah.
when the company can't have both, I have seen it practically in a public sector company that the situation comes.
I
Now,
know.
how to counter such kind of situations?
So legally, you have no option. If your tenure is also over 20-year, time is exhausted, you can go to NCLT. They may increase the tenure, but the instrument cannot be wiped out without unless and until you go for reduction of share capital. The option could be, if you are a public sector and you have accumulated losses, you file a scheme for the reduction of share capital, and on one hand the accumulated losses can be wiped out, on the other hand the preference share capital can be wiped out. That could be one option that can be explored. We have explored that in one of the case.
Yeah. The other point which was there was regarding 52 subsection 2 1D, and that is very clear that in case of India's companies, the source of payment of premium on redemption of preference shares will be profits only, and in case of non-India's companies, it can be both. It can be
Correct.
premium as well as the profits.
Correct.
So that law is very clear, but it is not a restriction imposed by the India's. It's a restriction imposed by the Companies Act itself.
Absolutely. Absolutely.
Yeah.
It is in the
No,
law.
that he has already explained. Yeah. Yes, Chandrasekhar.
Yeah. Amiji, good afternoon. Very nice, excellent session.
Yeah.
Amiji, one doubt about this. You were saying ISIN, if you're issuing a preference shares in one tranche, for each tranche, they're asking us to create a separate ISIN. Is there any way, like equity shares, can we have one ISIN for multiple tranches?
Equity share always will have a same term, right? Equity
Correct. No,
share-
I'm correct.
let me explain. Equity share, whether you are issuing today or you are issuing one year after or 2 year after or 10 year after, right? Equity share we are issuing which rank pari passu in all respect with the existing shares, right? So there is no confusion with regard to equity share. I think your question was primarily on the
Preferences.
preference shares which are issued in different tranches. I am saying my coupon rate is same. I am saying my other terms are same, right? Whether they are convertible, non-convertible, cumulative, non-cumulative, everything remains same. Only thing is that one instrument I am issuing today, one instrument I will be issuing 1 month after. I am saying instead of putting a term, you say these preference share will be redeemable on 31st March 2030. 1 month after also, when you issued the preference share, your preference share term says they will be redeemed on 31st March 2030. Instrument remains same. You have not put any term. You are saying they will be redeemed on particular date. Chapter ends. Your new ISIN will not be required. And we have done that. NSDL has agreed to our submission and they have issued the same ISIN for the purpose, and we have clubbed all the existing ISINs for the purpose. There is
Thank
no
you, Amiji. Thank you. If I may be permitted, I have one more question. Can I ask?
Please.
Yeah, please.
Amiji, though, in case of a redemption of preference shares out of fresh issue of shares, we are see already 1 crore paid up capital is there preference shares. Now, if we are redeeming out of profits will get minus, CR is getting created, money will go, share capital will become minus. If I'm issuing a share capital, already I have 1 crore share capital. Again, I'll issue second more 1 capital, then it will become 1 plus 1, 2 crores. I'm redeeming 1 crore is going on. So when I create a share capital of 1 crore, when I get share capital money, when I redeem, share capital is going minus. Does it amount to share reduction of share capital is my doubt.
No, it is not amounting to reduction of capital. That is provided in section 55 itself. If you are, that is why the CRR is created. See, please understand, profit and loss account is debited and capital redemption reserve account is credited, which replaces the existing preference share capital.
Correct.
And your balance sheet remains same.
Sir, my doubt is, second question, in the first is okay. When I have preference share capital of 1 crore, I am going for redemption of a fresh issue. I'll get one more crore share capital from the shareholders. Then 1 plus 1, my share capital is 2.
No,
Again,
one is redeemed now.
not redeem. See, redemption can make a one. See, right now, 1 crore is paid up share capital. I don't have money. I'll issue shares. Money will come. Entry is passed. PS3 is filed. My share capital is become 2 crores. Then again, I'm going past redemption. When I redeem, 1 crore is only going out. So 1 crore, when I'm reducing, does it amount? Is it permitted or does it amount to share?
Yeah. Please understand, when you are issuing fresh preference shares, your object is to redeem the existing 1 crore. You are mentioning that in your explanatory statement that the objective of this preference shares is to redeem the existing.
Okay.
It is only a temporary phase that your book entry will appear. Otherwise, the moment the capital is issued, the existing is redeemed.
Okay. Thank you.
Chandrasekhar, in simple term, what you are saying is by way of explanatory statement, I am replacing with the fresh 1 crore with the old 1 crore. That's
Correct.
all.
Rest is
In
the
the sense-
accounting entry.
Correct.
Maybe for a temporary purpose, I understand from where you are coming. For a temporary period, somebody can say that capital has increased from 1 to 2 and now from 2, again it is coming back to 1. So it is a reduction. No. Because that law has permitted, so there should not be any problem.
Thank you.
Okay, Karthik Jain.
Hello.
Yeah.
Good afternoon to all the panelists for the lovely session. I would just want to follow up on the earlier query that was discussed regarding bonus issue of preference shares to the equity shareholders. So just one combination I want to ask, supposing through a bonus issue, can we issue optionally convertible redeemable preference shares, OCRPS, or do we have to go through the scheme route only?
I think from a scheme only, because if it is convertible into preference share, I'm very sure I can do that without a scheme. But if it is having an element of redemption, I think as per my understanding, I have not seen a cases where it has been done. So it will be through scheme only. I'll have to but check again.
Okay. Thank you. Thank you for your time.
Yes, Raj Kar. Mr. Raj?
I think he's not there.
I think he's not there, I think so. Yeah.
Or by mistake.
There is one last question has come actually. So does it mean we don't need to file PAS 3 to the fresh issue of the SI7 for reduction of the shares and the reduction of the fresh issue redeemed out of fresh issue?
No, we have to file. We'll file PS3 also. We'll file SS7 also.
Also. Yeah.
Okay, that's all. That's all. I think session I can still see at the time. Now it is almost about 1:30, but still you see the number of it 125. That itself shows the importance of the session, and I'm very personally thankful on my behalf, but also I'm very sure our participants would have definitely benefited with your excellent experience sharing and various clarification which is actually given. Really, I am enriched. I also think everybody would be. There are a lot of appreciation has already come in the chat box, which I had not read actually. Many people have called the excellent session. Many people express thanks to you. Many people given you thanks for the various clarification. Excellent, Amit.
My
Thank
pleasure.
you.
And
Thank you, Amit. Thanks a
again,
lot for your experience and sharing your knowledge and lot of inputs from your side. Thank you, Shakshi, for your very good, well done presentation in a crisp manner. Thank you, Mr. Bala. Thanks, everyone. Thanks, everyone, for your participation. Thanks a lot. Thank you.
Thank you so much, ma'am.
thank you so
Amit,
much.
sir.
Have a good weekend.